Good afternoon. My name is Timothy Ward, and I would like to discuss with you the 1987 Supreme Court decision in McCleskey v. Kemp. I will do this by first discussing the specifics of the arrest, followed by the basis of his appeal to the Supreme Court, then discuss two background cases that relate to the appeal, and finally the Supreme Court's decision and the rest of the story. Warren McCleskey was an African-American male who was convicted of 2 counts of armed robbery and 1 count of murder in Fulton County, Georgia, in October of 1978. McCleskey was part of a 4-man crew who robbed a furniture store. Testimony and evidence provided at the trial indicated that all 4 of the men were armed and that the robbery was pre-planned. During the robbery, a white police officer responding to a silent alarm was shot and killed. Several weeks after the robbery, McCleskey was arrested on an unrelated manner and during the course of his interview admitted his involvement in the robbery. Evidence was presented that the weapon used to kill the police officer was the same weapon that McCleskey carried during the robbery, and 2 witnesses testified that they had heard McCleskey admit to the shooting. During the penalty phase, the jury found 2 aggravating circumstances to the murder. 1, that the murder was committed during the course of an armed robbery, and 2, that the murder was committed upon a peace officer engaged in the performance of his duty. Due to the aggravating circumstances, the jury recommended that McCleskey be sentenced to death on the murder charge and to consecutive life sentences on the armed robbery charges. The court followed the jury's recommendation and McCleskey was sentenced to death. Now, the basis for his appeal. McCleskey filed a petition for a writ of habeas corpus in the Federal District Court for the Northern District of Georgia. His petition raised 18 claims, 2 of which were that the Georgia capital sentencing process is administered in a racially discriminatory manner in violation of both the 8th and 14th Amendments to the Constitution. In support of his claim, McCleskey referred to what was known as the Baldus study. This study describes a disparity in the sentence of death to African Americans in Georgia based on the race of the murder victim and the race of the defendant. To summarize the study, it reviewed over 2,000 murders in Georgia and found that defendants charged with killing whites received the death penalty in 11% of the cases, but defendants charged with killing blacks only received the death penalty in 1% of the cases. One of McCleskey's claims is that the Georgia Capital Punishment Statute violates the Equal Protection Clause of the 14th Amendment. He argued that persons who murder whites are more likely to be sentenced to death than persons who murder blacks, and black murderers are more likely to be sentenced to death than white murderers. Thus, McCleskey claims that the Baldus study demonstrates that he was discriminated against because of his race and because of the race of his victim. Second, McCleskey claims that the Baldus study shows that Georgia's imposition of the death penalty violates the 8th Amendment, which prohibits the infliction of, quote, cruel and unusual punishment. Now for a couple of background cases. There were 2 significant cases prior to McCleskey that aided in the justice's final decision: Furman v. Georgia and Gregg v. Georgia. In the 1972 Furman case, the Supreme Court ruled 5-4 that the imposition of the death penalty in that case constituted cruel and unusual punishment based upon an apparent racial bias against African American defendants and therefore violated the Constitution. After the decision, the states had to rewrite their laws concerning the imposition of the death penalty in order to ensure that any discriminatory use of the death penalty was removed. The court's decision basically placed a moratorium on the use of the death penalty. The second influential case was the 1976 case of Gregg v. Georgia. Gregg was one of 5 cases that were reviewed to determine the constitutionality of the death penalty. In the court's 7-2 decision, it ruled, quote, that a punishment of death did not violate the 8th and 14th Amendments under all circumstances. In extreme circumstances, in extreme criminal cases, such as when a defendant has been convicted of deliberately killing another, the careful and judicious use of the death penalty may be appropriate if carefully employed, unquote. This ruling effectively lifted the 1976 moratorium. The Supreme Court's decision. The court, in a 5-4 decision, held that the Baldus study did not present substantial evidence that would necessitate overturning McCleskey's conviction. The court concluded that the lower court had properly applied Georgia law. The decision said that defense failed to show evidence of, quote, conscious, deliberate bias by law officials associated with the case, unquote, and dismissed evidence of general disparities in sentencing, such as the Baldwin study, as, quote, an inevitable part of our criminal justice system. Based on the Supreme Court's decision, Warren McCleskey was executed on September 25, 1991, after several additional failed appeals. Now, I offer this, the rest of the story and food for thought. I ask you, do you support the Supreme Court decision in this case? If yes, how much would your opinion change if you knew the following? Number one, the case against Warren McCleskey was extremely circumstantial, with no actual direct evidence that McCleskey was the shooter. Number two, the testimony against McCleskey came from 1, a co-defendant, as well as 2, a jailhouse informer. This jailhouse informer was promised a sentence reduction in response to his testimony. Number 3, 2 jurors stated that if they would have known about point number 2, being that the jailhouse informant with the promise of leniency for his sentence for his testimony, if they would have known about that, they would have not imposed the death penalty. Thoughts? Thank you, and have a great afternoon.